Yes, greetings to everyone. It's a great pleasure to welcome you to the last seminar of this academic year seminar series organized by the Climate Change and Law Laboratory of Kadir University, Faculty of Law. In the previous sessions of our seminar series, we had a chance to look at different problems associated with the climate crisis and its effects in various fields of law. Today, we will explore a new type of crime known as ecocide, which is added to the International Criminal Court as a fifth crime alongside genocide, war crimes, crimes against humanity, and crimes of aggression. And we have a very special guest, Professor Kate Mackintosh from USA. Firstly, I would like to thank you so much for accepting our invitation. We are very honored to host you in our seminar series. And before leaving the floor, I would like to introduce you to our audience. Professor Mackintosh is the inaugural executive director of the Promise Institute for Human Rights at Hukuk School of Law. She has worked in the fields of human rights, international criminal justice, and the protection of civilians for over 2 decades. She has held multiple roles at international criminal tribunals, working as a lawyer with the judges, prosecution appeals counsel, co-counsel for the defense, and finally, as an administrator, responsible as deputy registrar for the International Criminal Tribunal for the former Yugoslavia's court operations. For 8 years, she worked with Doctors Without Borders, providing legal and policy advice to operations in over 30 countries around the world, and leading advocacy in support of some of the world's most vulnerable populations. She was also part of post-conflict human rights field operations in Rwanda and Bosnia. She has lectured and authored numerous articles and reports on the principles of humanitarian action, international criminal justice, and the protection of civilians, and is currently thinking about the application of the Rome Statute to cyber warfare and how international criminal law can protect the environment. Professor Mackintosh is the co-deputy chair of Independent Expert Panel for the Legal Definition of Ecocide, which was launched in November 2020 at the 75th anniversary of the first use of the terms genocide and crimes against humanity. We are really very excited to listen from you how the concept of ecocide was born and being conceptualized in international law. And now the floor is yours, Professor Mackintosh.
Thank you so much for that generous introduction. And as you would have heard from the introduction, I'm very much a practitioner. So I'm just recently in academia, actually, for the last 4 years at UCLA in law school in California, and enjoying that very much. So I'm going to speak, as you heard, about the proposed new international crime of ecocide. But first of all, I want to talk about how it's not actually new at all, because I think it's very important to know that this is not a new idea, but an idea that has been percolating in international law circles for half a century. So the term itself is thought to have been coined either by biologist Arthur Goulston or by international lawyer Richard Falk, both of whom used it in the early 1970s to describe what was happening in Vietnam during the Vietnam War with the use of exfoliants like Agent Orange, which Professor Goulston, biologist Arthur Goulston, had been part of developing and was horrified by. And he used the term ecocide to describe what he saw happening. And in 1973, Professor Falk actually came up with a proposed international convention on the crime of ecocide. And he was inspired by the Genocide Convention. And he developed a proposal which enumerated a number of acts, including, interestingly, using weapons of mass destruction, as well as forced displacement of people and animals that could be committed in time of war or peace with the intent to destroy or disrupt in whole or in part a human ecosystem. So you'll hear there the echoes of the genocide inspiration for that. So that was in 1973. A few years later, the destruction of the environment during armed conflict or for other hostile purposes was prohibited by two new legal instruments. So in 1977, we had the first additional protocol to the Geneva Conventions applicable during armed conflict. And in 1978, a convention known as the Nmod Convention, with a very long title, about prohibiting military or other hostile use of environmental modification techniques. And both of these prohibited, well, they use slightly different terms. They prohibited harm to the environment. Additional Protocol 1 prohibited widespread, long-term and severe damage to the environment, while the Nmod Convention prohibited widespread, long-term or severe damage to the environment. And I flagged that because that is a question that we came back to in our deliberations on the panel when we were looking for an appropriate threshold of harm. So we had these two different examples, the cumulative, widespread, long-term and severe, or the disjunctive, widespread, long-term or severe, already existing in international law. So in the 1980s, the UN Human Rights Subcommission on the Prevention of Discrimination and Protection of Minorities, the precursor to the Human Rights Council today, proposed broadening the definition of genocide, going back to the genocide analogy again, to include adverse alterations to the environment which threaten the existence of entire populations, and again referred to nuclear explosions, but also to the destruction of the rainforest, interestingly. So that's in 1985. So we have this thread of concern about the environment, in particular as it affects people, since the 1970s. In 1991, the International Law Commission, in its work on the Draft Code of Crimes Against the Peace and Security of Mankind, proposed a crime of willfully ordering or causing, or willfully causing or ordering to be caused, I should say, widespread, long-term and severe damage to the natural environment. So again, taking that cumulative threshold from Additional Protocol 1, but this time suggesting that it would be a standalone international crime that could be committed in time of war or peace. So that was in 1991. It stayed in the work of the International Law Commission for just 4 years. In 1995, the idea of the standalone crime was dropped, and the idea of prohibiting widespread, long-term and severe damage to the environment in conflict was retained. And in 1998, of course, the Rome Statute of the International Criminal Court was drafted, and you will be aware that there is a prohibition, there is a war crime of causing widespread, long-term and severe damage to the environment in the Rome Statute in its Article 8.2b4. And it's a little more complex, and we'll go back to it, but that's where that strand of legal thinking ended up around the creation of a new international crime. So that's the 20th century. Moving to our current century, there were a number of private initiatives starting about 10 years into our current century. So very famously, the activist and lawyer Polly Higgins from the UK campaigned around the idea of a crime of ecocide. But also in France, there was a lot of activity. Valérie Cabanès, who was on the panel with me to define the new crime, also was leading an initiative to create a new crime of ecocide. And there was a broad coalition headed by Professor Laurent Neyret, which actually proposed a draft convention on the crime of ecocide in 2015. So all this to say that the work that I'm here to speak about really builds upon the work of so many other people, and that the crime of ecocide has not fallen from the sky, although the current situation that we're in and the extremity of the climate crisis, I think, has given it more purchase, more urgency, and certainly I feel has led to it being taken up with interest in circles that might not have taken it seriously just 10 years ago. So in the introduction, it was briefly explained that I was part of this panel that was convened then on the shoulders of all this other work to draft a new definition of a crime of ecocide, specifically for incorporation into the statute of the International Criminal Court. And why was it useful to look again when we already had some existing draft definitions? I think because the law, the international criminal law, has developed so much in the first 20 years of this century. And particularly, of course, the law of the International Criminal Court is much more recent. So to draft a crime that had a chance of success of being incorporated into the statute, we really had to draw upon these criminal law notions that have been developed quite recently and make sure that we drafted the crime in the language, in the current language of the statute of the International Criminal Court. So to this end, the Stop Ecocide Foundation, which is a private initiative, convened a panel of 12 jurists, and I think it was brilliantly put together. I mean, I had a wonderful time discussing with my fellow panelists, because the panelists really represented not only very geographically diverse group, but also an intellectually diverse group, and scholars and practitioners and activists that brought knowledge not only from international criminal law, but also from international environmental law and from international climate law. And I know that one of my colleagues, a climate law professor, Christina Voigt, has previously talked with you on one of these seminars. So we worked together on the definition, which I'll run you through in a moment. And we worked over a period of just 6 months. The panel was chaired by Philippe Sands and Dior Falsao. So it was an intense piece of work, and we issued our definition in June 2021. I thought just before I show you the definition, and I'll share my screen so you can see the text, I might just address the question of why international criminal law. Like, why is that a useful tool to combat the climate crisis? And I would say, first of all, that clearly it cannot be the only legal tool. And I'm really delighted to see the breadth of creative legal thinking and activism that is going on around the climate crisis. And, you know, the climate crisis, the biodiversity crisis, and the toxics crisis, the triple crises that we're facing. But I do think international criminal law has an important role to play. And perhaps its almost most important role is the expressive value. I think we should not underestimate the importance of stating as a global community that we think that we recognize that destroying our environment is on a level with the other international crimes, with crimes against humanity, with genocide, with aggression, with war crimes, that it's clearly an issue of international concern, and that all of us consider is beyond the pale, an issue that can no longer in its extreme form be left to individual states to regulate. And I think that is a very, very powerful message. And that may be one of the most important effects of adopting ecocide as a new international crime. It's a shift in thinking, it shifts our narrative, and I hope it would shift behavior. But there are other practical aspects which could also be advantageous. And one of them, which we may discuss more in questions, is the issue of jurisdiction. So of course, there is at least potentially universal jurisdiction for international crimes. But there's also some very interesting opportunities for jurisdiction that an international crime of ecocide opens up. And we might think, for example, of the question, you know, where has the crime occurred? Particularly, I mean, at the most extreme, if we think about a crime associated with emissions and climate change. But many environmental harms happen across borders. And so they offer an opportunity for jurisdiction in a number of different states. And that's also relevant, of course, to the issue of the only partial ratification of the Rome Statute. So I think jurisdictionally, international criminal law opens some really interesting avenues. I think in general, criminal law is appropriate because the other kinds of legal action, particularly all the tort suits, you know, there are absolutely brilliant creative actions taking place all over the world where the victims are claiming that they've been harmed in different creative ways and trying to obtain judgments that will protect not only them, but all of us from the environment. But in those kinds of legal actions, the burden is very much on the victims. And I think we all recognize that in the case of environmental and climate harms, those most affected tend to be the most marginalized, those with the least resources, those the least able to carry the burden for the rest of us. Criminal law does completely the opposite. It takes the burden away from the victim and is a consensual action from all of us to say, we think this shouldn't happen. So I think that's also a value to approaching this pressing issue through criminal law. And then finally, I think the impact on corporate actors of an international crime of ecocide is really potentially very interesting. and that the deterrent value of being even accused of ecocide, let alone being convicted of ecocide, might be much higher for corporate actors than it is for political actors. Corporate actors are, of course, not ideologically driven. They're driven by share price and profit motives, reputation. So the threat of being indicted for an international crime, I think, could really lead to a change in behaviour at the corporate level, which is so important. Okay, so what is this crime? I'll share my screen so that you can see the text, because it's hard, I think, to follow probably without that. So I hope that you can see now what we suggest for Article 8 ter. So it would be the 5th crime in the statute. As you, I'm sure, all aware, there's already Article 5, crimes against humanity, Article 6, genocide, Article 7, Article 7 is crimes against humanity, sorry. Article 8, aggression, and then Article 8 bis aggression, Article 8 war crimes, Article 8 bis aggression. And so we slip in Article 8 ter as ecocide, so they wouldn't have to renumber all the statute. And we just have one very short paragraph. For the purpose of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And then I will come back to the text. We have a second paragraph where we define a number of those terms. So I'll go through these. I'll go through these in a moment. So as I said, our one of the guidelines that we had was to try and draw as far as possible on existing international law and international law concepts for a number of reasons. I mean, that's the way international law works. But also we felt that our chances of success of actually having this adopted were much higher if we could show that we were drawing on international law concepts, in other words, concepts that have already been agreed between states to exist in international law. So a couple of points to note then. First of all, we've crafted this as a crime of endangerment rather than a crime of material harm. So if you look at the text of the crime, we actually don't, the criminal act is creating a dangerous situation. It's creating a substantial likelihood of severe and either widespread or long-term damage to the environment. So you don't have to wait for that damage to manifest before the crime has been committed. And this, there are a number of other crimes of endangerment in the Rome Statute. For example, the existing crime of causing harm to the environment, which is actually about also about the creation of a dangerous situation, launching an attack in the knowledge that it will cause widespread, long-term and severe damage. So it doesn't require the attack to cause that. It's about launching the attack, creating the situation. And also Additional Protocol 1, which I referred to as one of the source documents, the 1977 Additional Protocol 1 to the Geneva Conventions. Actually, the language there, they prohibit means and methods of warfare which are intended or which may be expected to cause widespread, long-term and severe harm to the environment. So we drew on that to craft a crime of endangerment, which we thought was particularly important in the fields of environmental harm because, well, first of all, the deterrent effect may be greater, but also it's not always 100%, it's not always easy to draw with 100% certainty the line of causation between the acts and the result. And so it might exclude acts that we felt really should be captured by ecocide if we required acts to manifest and for that causal link to be proved 100%. The scientific advice we received was that it would be, however, possible to reach the threshold of substantial likelihood, but that's where the science is today. And as we have legal precedent for that, we went with that option. So there are two thresholds in the crime. And the first I just mentioned is the knowledge of substantial likelihood of severe and either widespread or long-term damage. Now, I flagged earlier this idea of conjunctive and disjunctive with the three terms severe, widespread, long-term. So in Additional Protocol 1, they're conjunctive, it's all three, and also that's also the case in the current war crime in the Rome Statute. Whereas in the Nmod Convention, they're disjunctive, severe or widespread or long-term. Well, we all agreed that disjunctive would not work because there couldn't be an international crime when the damage was not severe. So severe had to be in there. And then we have many, many discussions about whether it should be severe and widespread and long-term. And in the end, we came up with this solution, severe and either widespread or long-term. And the reasons for that were we were running through, or people came up with examples. For example, an environmental disaster that harms very many people, but perhaps just in one town, which might not meet the definition of widespread. Or long-term damage, does it have to be long-term because we want to also deter damage that that might not last forever, but that would be catastrophic. So we decided that severe was obligatory, and then it had to be either widespread or long-term. And as that's a midway between the two existing legal precedents, we also hope that that will be acceptable. To dive a little more into those definitions, severe, widespread, long-term. Severe, we actually were able to draw upon the definition of severe from the Nmod Convention with just one small modification. So the definition there, as modified by us, severe means damage which involves very serious adverse changes, disruption or harm to any element of the environment, which is important, including grave impacts on human life or natural, cultural or economic resources. So our modification was to add the word cultural there, which is not in the Nmod Convention. And with that, we want to indicate that destruction of elements of the environment which have a cultural value, and I'm thinking, of course, of Indigenous peoples and their relationship to the land and their own territory, that would be an aggravating factor that would count towards a consideration that damage was severe. And I also draw your attention to the fact that it's harm to any element of the environment, including grave impacts on human life, but not requiring grave impacts on human life. So we do not require there to be a human impact of the damage for it to count as severe. Then the other two terms are widespread or long-term. For widespread, and now both of these did have definitions or potential definitions in the commentaries to both Nmod and the Additional Protocol 1, which we rejected. Widespread was either several hundred square kilometers or thousands of square kilometers in the Nmod and Additional Protocol 1 conventions, which we thought was arbitrary, hard to measure with climate harms. And again, we came back to this issue of, well, what about thousands of people in one city and so on? So we drew on a couple of other sources for our definition, which is damage which extends beyond a limited geographic area, crosses state boundaries, or is suffered by an entire ecosystem or species, or a large number of human beings. So beyond a limited geographic area is our nod to the existing definitions in the commentary. Crossing state boundaries, of course, is looking at the principle of prohibition of transboundary harm in international environmental law. Suffered by a large number of human beings draws on the definition of widespread in the crime against humanity. And we've added to that or an entire ecosystem or species to move away from a purely anthropocentric approach. And then long-term, very briefly, again, the existing suggestions with the in the definitions of widespread, long-term, severe varied from several months with the Nmod Convention, which none of us felt was long enough, to several decades under Additional Protocol 1, which we thought, again, might be too long and also seems somewhat arbitrary to just pick a period of time. So we tried to define it in a different way. And our solution was damage which is irreversible or which cannot be redressed through natural recovery within a reasonable period of time. I'll just briefly mention that we also define environment. So environment is famously not defined in international law. So we took a risk here, but that was the feeling of the panel, that it was important to give some kind of definition. And so we've drawn upon scientific sources rather than legal ones for that one. The second threshold then is that the acts have to be either unlawful or wanton. And unlawful speaks for itself somewhat, although we did leave open whether that would be unlawful at national or international level deliberately because of the dearth of outright prohibitions at international level, and because so much of environmental law is actually determined, or the lawfulness of certain actions is determined at national level, taking into account the principles that are established at international level. So we don't define unlawful, but we leave open that that could be at national level. However, clearly, we couldn't just have national law determining whether or not a crime of ecocide has been created, because that would be unequal. There will be jurisdictions where there should be something should be prohibited but isn't. It couldn't be just that. And at the same time, international level is not adequate because of the lack of prohibitions at international level. So we had to craft a standard that would render environmental damage ecocide, even where existing prohibitions were absent. So, for example, an act which is not prohibited outright at international level, which is, there are very few prohibitions apart from maybe the transport of dangerous waste or the ozone layer, and also not prohibited at national level. And of course, we can all think of examples of terribly destructive acts which are tolerated or even encouraged at national level. We had to think of a new standard, to craft a new standard. And our solution was this term, wanton, which we then defined as with reckless disregard for damage which would be clearly excessive in relation to the social and economic benefits anticipated. And what we meant by that was really reckless and wasteful behavior, because we realized through consideration of a number of examples that the environment is damaged consensually and in accordance with principles of sustainable development, all the time. So we can agree as a community that we will, cut down a particular area in order to construct housing, which is desperately needed. Our relationship with the environment is not to leave it in a state of pristine wilderness, but to use it. The important thing is in a sustainable way. So we try to incorporate that principle of sustainable development into our international crime. And we've done that through the term wanton. And I could talk a lot about wanton, but I don't want to go on too long now. But for me, wanton is also the window through which this international crime can speak to the whole framework of international law, particularly international climate law, and all the negotiations that are going on about how to avert the crisis on a consensual interstate basis. Because we can't create a crime, we can't criminalize an act at an international level that is not only tolerated, but part of an agreed framework by states. The two frameworks have to be able to speak to each other. And in my view, in my understanding, the term wanton is the term that allows that same balancing that happens in international environmental law at national or international level to happen in the determination of this crime. So that comes to the end of my definition of the crime and of our proposal. Just very briefly, what needs to happen now? Well, one member state of the International Criminal Court needs to propose the amendment, and we very much hope that that will happen this year. And then it will be discussed by all the states parties of the International Criminal Court in their annual meeting in December. Any amendment has to be proposed 3 months before the meeting. So we have a September deadline to get the states to propose it. There are a number of positive moves in that regard. We have a number of states that have spoken at the Assembly of States Parties in favour. We've had just recently resolutions in the Belgian Parliament as well as in the European Commission supporting a new international crime of ecocide in the statute of the International Criminal Court. So I'm hopeful that we'll be able to at least meet that initial target, and then it will be up to the member states of the ICC to see what they do with that amendment. So with that, I'll finish my opening remarks, and I look forward very much to conversation with all of you.
Thank you so much, Professor Mackintosh, for this very comprehensive lecture. I have really learned a lot about ecocide. Thank you so much. We have now some questions prepared for you. After those questions, we can ask our audience to have their questions and comments. So I would like to ask, firstly, in a scenario where ecocide is defined as a crime, should we be responsible from the actions in which we harm the environment indirectly?
Thank you. I think that's a really interesting question. And what I'm reading behind your question is the issue of, you know, this is especially around climate change. You know, are we looking at some kind of systemic crime in which we're actually all playing a part? And obviously the crime of ecocide would not be targeting us as individuals. I mean, even though we may drive cars and fly planes and use disposable plastic forks or whatever bad things that we shouldn't be doing, the idea, of course, is not that that would be captured at the international level. So our attempt to deal with that question is really in the threshold of gravity. So one individual, through their own actions or their own decisions, would have to have the potential to cause you know, a substantial risk of severe and either widespread or long-term damage to the environment, but through their own actions. So we're not looking at individuals. We're really looking at people who are in a position of, you know, much greater authority. You might think of environment ministers or CEOs of fossil fuel companies, or, you know, somebody whose own actions and decisions could reach that threshold. So I think that's how we deal with that issue that you raised.
Yes, yes, exactly. Thank you. How can we make companies liable from ecocide? As we understand from your answer, companies or CEOs can be liable, but how this will work?
Yeah, well, no, I mean, it's really important to point out that while we could look at an individual CEO from a company, the company itself, the corporate entity, cannot be prosecuted at the International Criminal Court. So International Criminal Court, as you'll be aware, only has jurisdiction over natural persons. And this is something that's been you know, criticised very broadly. And there are a number of people who are writing about how the statute should be amended to include corporate criminal responsibility. But that's not currently the case. And we thought we should just deal with one amendment at a time. So corporations themselves won't be held responsible, but I'm not sure how problematic that is. I mean, there could be some issues about, you know, there could be some issues around the corporation being responsible, somehow holding, you know, that being more of an indictment against the image of the corporation. But I actually think that holding individuals responsible could be very, very useful in this kind of situation. So I'm imagining, you know, the board meeting where the board of directors are sitting around the table discussing some new action which will potentially cause widespread long-term or severe damage to the environment. And the in-house counsel says, you know, I should tell you that this could potentially have you all being individually liable for ecocide. And I mean, I imagine that will change behavior at that stage. You know, so yeah, it's a corporate criminal liability is not an option at the International Criminal Court, but of course, individual corporate actors could be held responsible.
Yes, yes, I understand your point. And I think this next question is related to this one. In case that the ecocide is accepted as a crime, can it be applied retrospectively? So that from now, should the CEOs be careful on their decisions?
Yeah, I mean, that's such an important question. It could not be applied retrospectively. And that's another limitation of a criminal law approach, of course, because the claims for reparations, you know, the civil law claims, of course, can take into account historic harms, whereas criminal law can only be forward-looking. So nobody could be held accountable for their actions before those actions were actually criminalized. So it's only forward-looking. So it's very much looking at altering behavior from now on.
Yes, yes. The point is to change their behavior from now on.
Exactly.
And would it be possible to amend the Rome Statute of ICC, or would it be more sufficient to create a new international instrument or treaty? I'm sure you have discussed this possibilities during your internal discussions.
Absolutely, yes. I mean, I'm certainly not against the idea of a new treaty. I think it offers, possibilities which ratifying or amending the Rome Statute does not. It would mean, there are certain parameters in the Rome Statute, like the absence of corporate criminal responsibility, for example. And I'd note that the draft Crimes Against Humanity Treaty, which is in final draft form, does include corporate responsibility, so that it is possible under general international law for a corporation to be found responsible for an international crime. So that and other limitations of the Rome Statute, another very practical one is, 123 states are parties to the Rome Statute. So that means there's an awful lot who aren't. And among the ones who aren't are, China, Brazil, India, the US, states that are responsible for a lot of damage to our environment. So there's certainly some very good reasons for pursuing an independent treaty, although whether those states would support a new independent treaty, of course, is not clear. Our thinking was that it would be a little odd not to address the Rome Treaty, as it is the existing, most authoritative source of international criminal law. It is a functioning institution. It does have 123 states who are members. So we felt an amendment to the statute was appropriate, but I don't think it closes down other options.
Yes, I see. Thank you. In case of the amendment of the Rome Statute or formation of any other international instrument or treaty, how the non-signatories to these instruments can be bound with or keep liable with these offenses?
Yeah, right. Yes. Well, that's exactly. That's the big problem, of course, and the big limitation of the Rome Statute. So maybe I could go back to something I alluded to in the presentation about jurisdiction, which I think is really interesting. This is not the purpose. This is not why we drafted any of the definition in the way that we did, but it's just something that it occurs to me is, will be very interesting if it is adopted. For the prosecutor to consider. So you'll be aware that there is legal authority on talking about where a crime is committed. It may be that the crime is committed. One of the places it's committed is where its effects take place. So we could very much imagine a situation in which an environmental harm was carried out by a company. The nationals of the company are from a state that's not party to the statute. The company itself, so the decision was taken on a territory of a state that's not party to the statute, but the effects of that decision are felt on the territory of a state that is party to the statute. Well, I would argue that the ICC will then have jurisdiction over those actions. Further, there's been the decision in the Myanmar case that, which is the case of the Rohingya being forcibly displaced from Myanmar to Bangladesh. And the court held that because part of the crime occurred in Bangladesh, because forcible displacement must occur across a border, because part of it deportation rather, because part of it occurred across a border and in Bangladesh, and because Bangladesh is a party to their own statute, that the court would have jurisdiction over the crime, even though Myanmar is not a party. So I think there are a lot of interesting, I think just the fact that a state is not party to their own statute will not be a reason for them to feel that they're not concerned by new international crime of ecocide in the Rome Statute. I think it's quite complex thinking about which actions will be caught, and I would hope that it would be really quite influential actually in decisions also of states that are not parties.
Yes, thank you. And another question in this respect is what is the importance of term mens rea in Rome Statute or any other international instrument or treaty in terms of ecocide discussions?
So the Rome Statute has a default mens rea provision in its Article 30, where it defines mens rea, but it's clearly a default position. So it is possible to define a different mens rea in the crime, and we have defined a different mens rea in our crime. We have defined a somewhat lower mens rea. We have our knowledge of substantial likelihood, because the current definition in Article 30, the jurisprudence has held that the effects of a crime, it has to be a practical certainty that they will occur. And as I explained, we felt that for environmental damage, that was too high, that would not work. It wouldn't catch, and it would be very, very difficult for the prosecutor to prove that that these events were a practical certainty, just because the science has not reached that level in many situations. I mean, sometimes we can imagine, think of an example. So if we imagine like an oil tanker which runs aground and there's a huge oil spill, well, it might be possible there to use usual principles to look at how foreseeable that damage was, whether it was, whether it had been maintained, whether it was an almost certainty that that could happen. But there are a lot of other climate and environmental effects it's much harder to draw that line. So we've suggested this idea of knowledge of substantial likelihood, which we think is sufficiently robust. It's justifiable for an international crime. Obviously, the mens rea has to be a fairly high standard, but it's not so high that actually it would be impossible to prosecute any crimes.
Thank you, Professor Mackintosh. Another question is about relates to the definition. There is no list of acts which can be deemed as ecocide. Would it make a problem of clarity in terms of a general criminal law perspective?
Yeah, that's a great question. And we talked about that a lot in the panel. So we did consider going the other route and having a list of enumerated acts, and then we would have had a final paragraph which said something like, any other similar acts or other acts of a similar character. So following the Article 7 Crimes Against Humanity enumeration. In the end, we decided to go for the short paragraph. There was some anxiety among some members of the panel that enumerating acts might suggest, even with the open list, might suggest that other things were permitted, that new dangers can arise that we don't understand in our current state of scientific awareness, and just perhaps a feeling that shorter was more elegant. I think it's 50-50. It may well be, because if the amendment is accepted in December or subsequently, it's not that the whole text of the amendment will be accepted. The member states will accept to consider it, and then they themselves will work on the amendment. So, it may well be, in fact, it's very likely that any ultimate crime looks completely different to the one that we've suggested. Our goal was really just to suggest something which was credible enough to start that conversation. So it may well be, for example, that the crime ultimately does end up with an enumerated list, which would be in line with some of the other crimes in the statute. I think it's a good question. And we came down on one side, but there are very strong arguments for the other as well.
Thank you. And finally, will the crime cover disruption of indigenous ways of life?
I think it will. It depends at what degree. Of course, it would have to be severe, as we suggest it to be defined. But as I mentioned, we did add in that definition of severe the fact that severity can also be judged by the impact of the environmental harm on cultural resources. And our idea there was really to make a harm to culturally significant ways of life or elements of the environment an aggravating factor in determining severe. So really to make clear that, the fatal pollution of a river and the killing of the salmon stock, and I'm thinking about a river in the north of California that is central to the life of the Yurok tribe, for example. And I've been speaking with their legal counsel about the impact of that pollution of that river on the way of life. And our idea is that by putting that word cultural in there, we explain that it's not just the fact that the river's polluted and that the fish have died, it's that a whole way of life of the Yurok people, you know, who lived from the salmon and who have a spiritual relationship with the river has been harmed, and that should be taken into account in assessing whether or not the damage is severe. So that's that was our attempt at ensuring that it would cover at least severe disruption of Indigenous ways of life.
Professor Mackintosh, thank you so much for these comprehensive answers. It has been a privilege to see the approach and understanding of the drafters of the crime of the Ecocide. Thank you so much. Now we can continue with the questions or comments of the audience. And I see a hand raising. Mr. Nathan Sprowney, if you allow me, I will let them talk.
Thank you very much, Professor. I hope, first of all, I'm clear that I'm audible, sufficiently audible.
Absolutely.
Thank you. You have warm greetings from the Republic of Kenya. I am in Nairobi. First of all, just let me pass my greetings to Professor Slihan, my teacher, almost my mentor, who has been with me for the last, I think, 3 years since I joined Kadir Has, International Law of the Sea Academy. And I hope, looking forward to being there again in July. And thank you, Professor, for inviting me to these. I haven't missed out on any. I've been part of this team, and I thank you very much. So let me go straight to the point. First of all, by the way, it's not 7 a.m. I think it's 7 p.m. Kenya and Turkey and Istanbul, we share the same time zone. So it's about now 1950, which is about evening time. So it's not a.m. It's not in the morning. It's evening.
Okay.
Yes, you've really touched on what you call a live wire issue, a raw nerve on this crime. And please allow me to give you the background, because it really affects not just Kenya, but the entire continent of Africa. And you may not see my video. You probably not see me fully because I stopped by the roadside to get this on, because a number of us are on the way to attending the funeral of the third president of the Republic of Kenya, His Excellency Mwai Kibaki, who died a few days ago and is being buried shortly in his home. So we were all headed there, and I knew because of the time zone, I had to pull by the side, and I'm in my car, in fact. That then goes to the root of what you're saying. President Kibaki, at the time, the late now, lying in state, his body just left the House of Parliament. In 2008, he was the supreme leader of the Republic of Kenya, and there was skirmishes and chaos arising out of post-election violence, and 1,200 people died. And his lieutenants were taken to the International Criminal Court under the provisions of the Rome Statute, genocide, and all those crimes that you can read through. So they went through that, and the current president who succeeded the late president, now lying in state in the House of Parliament, and his deputy were charged at the criminal court, the International Criminal Court. So this is a matter of public record, it's not anything private. Of course, they were acquitted. They were then running for office in 2013. 2017, they succeeded, and now the president is leaving office. The vice president, deputy president is running, and the president is not supporting him, but the president is supporting the opposition. And that presents a very complicated web of issues. Environmentally speaking, you have two divides. The deputy president comes from an area environmentally delicate, from what you'd call the Elgon part, Elgon Mountain, overlooking the Republic of Uganda, the DRC, Democratic Republic of Congo, Rwanda, and Burundi, the other side. The president himself, the current president, comes from the Mount Kenya region. You probably know Mount Kenya as the finest mountain you have in Africa. So the damage that was caused upon the environment as a result of acts. Now, I want us to be very careful whether there were corporates who are involved or individuals in the name and style of the president or the presidency, meaning including the deputy president, or indeed other players who are not even in the presidency. And I like what you said, Professor, that this may not apply retrospectively, but it's an area of research where a lot of the indigenous peoples now, we are speaking of the hunter-gatherers, they're called the Ogiek, the East African Court on the Peoples and Human Rights granted them an order that they can now be restored and taken back to their homes. Just the long and short of it is this, so that I can attract your response. I'm sure we can engage on this, and you can look this up. It's available everywhere on the web, but just to get to the bottom of it. At a national level, you have the Constitution that says every person, every citizen shall enjoy the right to a clean and healthy environment. At a regional level, you have exactly the same. At a global level, you have the Convention on Biological Diversity, you have that on the law of the sea, you have, and very many others, including those that affect animals, on CITES and so on. So what is it then, as the international community, should we do to ensure that as we move forward, now that you said this cannot or shall not apply retrospectively, what is it, especially for those of us who know and have witnessed a damage to the environment as a result of acts or omissions on the part of individuals at a very high level? And I was listening very carefully how you said it could be heads of parastatals or quasi-state agencies, ministers, and I think you stopped there, but I dare say we could add and go to heads of state, because the environment, as we've learned, belongs to all of us. In fact, if you look up Article 69(1)(b) of the Kenyan Constitution, and I hope I can, yeah, and I'm clear it's that, obligates every citizen, so that it's not limited to a president or to a farmer or to a small person. So I'm saying the obligation that we have to protect and conserve the environment from a climate change perspective, biodiversity, and all that. So you're looking at forests that have been affected, the Elgon, Mount Elgon or Mount Kenya, where you have rainfall that is right now, the entire region is suffering, and drought being a real major cause of concern. The World Food Programme is giving food to those drought-stricken areas of the north and Kenya and so on and so forth, as a result of actions or acts of or omissions of individuals or groups of individuals or persons or corporates, or in this case, again, we dare add government. So how do we proceed to deal with the matter of this multidimensional perspective, so that, I'm sure you don't have to have an answer right there, but I just thought I should share this so that we look at it, and I really want to support the discussion around this subject, because it is so important. The final point, which is really my second point, on definition. When you said, Professor, that you had to look for a new definition, I think there is been definitions given under, as I said, the 1992 Convention on Biological Diversity, the CITES, the United Nations Law of the Sea Convention of 1982, signed at Jamaica, Montego Bay. There have been many definitions relating to the environment. And in fact, at a local level, we created in 2013, and I had the privilege of being the lead drafter on this one, what you call the Environment and Land Court, so that everything has to end at that court. So an appeal can only lie to the High Court, no, actually to the Court of Appeal and the Supreme Court of Kenya, because the High Court and the Environment and Land Court are deemed to be of the same status. At a regional level, you have the East African Court of Justice, and the one I mentioned on human and people's rights. And then, of course, at the international level, you have now the International Criminal Court. So I am looking at the interdependence of, in terms of jurisdiction, the national, the regional, and the global. So it's an area I thought I should share with you. I don't even think this was going to be like in the form of a question, but it's a commentary by way of supporting what I have heard from you as one of the most brilliant presentations of our time. An excellent rendition. And I hope that moving forward, we all can get involved in understanding how this new quote unquote crime falls into place. My only concern is that if we say it's only for the future, then those who have committed, I know retrospective, applications are very difficult to deal with under the law, whether it's from a criminal or civil perspective. I thought really I should say thank you, Professor. You made my evening, even as we mourn the death of our third president, those of us who have worked very closely with him. So I'm on the way to his burial, but I thought I should stop by because Professor Slehan had indicated that this was scheduled. I couldn't possibly ever miss out on this, and I truly don't know how to say how honored I am that I've been a part of this, and I will forever remain grateful to you, Professor, and both professors. Thank you very much. It's been a mouthful, but forgive me. I had to bring this out. Thank you very much, both Professor Slehan and Professor, the presenter on the floor. Thank you very much.
Thank you so much. It's Nathan's, is it? Yeah, and and my condolences, of course, on the very sad death of your third president, and my greetings to the beautiful Kenya, which I know quite well. What a wonderful country. You made a comment, but just to reflect on a couple of the points that you raised. First of all, I think you're absolutely right to point out that we need a network, we need legal action on so many levels. And at the beginning, I emphasized that international criminal law is just one tool, and the other legal efforts that are going on, whether that be at state level or whether that be through victims claiming reparations or human rights claims, all of these are hugely important. And I'm just arguing for the added value of an international crime, which I think you also support. But I absolutely agree with you on how important all of those efforts are. And as to the definitions, I think those definitions, Convention on Biological Diversity, CITES and so on, those are of course sources which might be used if the crime had enumerated acts. That's one thing that we did. We considered framing the enumerated acts around areas which have been regulated by international law. But in the way that we framed the crime, of course, those were less useful, but they're certainly useful in terms of analysing individual crimes when they happen. The one difficulty with those crimes is they don't necessarily create unlawful acts, but they certainly create some useful legal parameters. And then with your point of no retroactivity, again, I think that points again to how important it is to keep these legal efforts going on all fronts, including those which will account for past damage to the environment, even as we look forward with the crime of ecocide. So thank you very much for your contribution.
I think we come to the end of time allocated to us. I think, yes, there is another hand raising. Yes, Yavuz.
You are muted, I guess.
Hear me? Thank you very much, Professor. It was a very interesting. Presentation. I have a question on the definition of the unlawful in that provision you have shared with us. So firstly, it is very much intertwined with the jurisdiction issues. So I have to give a presentation, a background to my question. So as far as I understood, as far as I could pick up on your ideas, a universal jurisdiction is necessary to implement this new criminal provision. Is that correct? Because otherwise it is almost very difficult to really ensure its uniform application. For instance, someone can commit that crime in the open sea, and if there is no universal jurisdiction, then the Ecocide provision is merely useless. Is that correct?
Not exactly. So the open sea question is a very interesting one, but the International Criminal Court has jurisdiction in two ways. One is territory, and the other is nationality of the perpetrator. So if a crime were to be committed outside national territory and not to have any effects which manifested in national territory, there would still be recourse to, we could still look at the nationality of the perpetrator to see whether there was jurisdiction. I think the point about universal, if the crime is incorporated into the Rome Statute, then the rules of jurisdiction that are established by that statute will apply. Generally, though, the states that incorporate the crime into their own domestic laws, which is what they'll do, obviously, and they have primary jurisdiction themselves, they often will include universal jurisdiction for those crimes, as they have done for other international crimes, because under general international law, there is jurisdiction to, there is universal jurisdiction for international crimes. So in many countries, I'm not familiar enough, forgive me, with the situation in Turkey, but the criminal codes of countries that I am more familiar with will permit, prosecution of, for example, genocide, wherever the genocide took place and whoever the perpetrator was. So it is likely and certainly possible that the crime of ecocide would fall into that category, and that states would introduce universal jurisdiction.
So pardon my criminal law knowledge, I was never good at it, but that was the point I was trying to arrive. So it is possible that we have universal jurisdiction provisions in national criminal courts.
Exactly.
So at that stage, my question comes into play, the definition of unlawful. For example, let's assume that Japan gives licenses to fishermen for fishing whales and dolphins. And Japan has exclusivity in such activities in its exclusive economic zone, unless such fishing activities are optimal, according to the UNCLOS. And an action which may fall into the ambit of a lawful action may very well become unlawful, for example, according to Canada. And if we assume that there is universal jurisdiction in this regard, how are we going to deal with a fishing activity which has occurred within the Japanese exclusive economic zone, which is lawful according to the laws of Japan, and Japan has exclusivity to legislate about the fishing activities in its EEZ? So,
that's a great question. That's fantastic. Yeah, okay, I get you now. So you mean something, if we don't have to resort to wanton, because that's where I thought you were going. I thought you were going to say, what if an act is, egregious but lawful? But what you're saying is, what if an act is lawful and then unlawful somewhere else? And so the Canadian prosecutor decides that they would want to prosecute it. Yeah, I don't see an immediate solution to that issue. I imagine that there would be some serious consideration on the part of Japan, and who might well resort to some international body to give some kind of advisory opinion on how that should be proceeded with. But that would be a clash of laws, without a doubt. Yeah, that's a very interesting point. Thank you.
Thank you.
Thank you. And Murat Ceyhan is also raising his hand.
Thank you so much. I've been really enlightened by your perspective, and this has come to be an issue for such a criminal law, general provisions, special provisions type of approach. This is a brand new, actually, chapter for me as well. So thank you so much. I will just provide a brief question, and I should not take your time so much. As you have mentioned, this year will be the time when a country actually introduces this comprehensive and much needed amendments. But do you expect any backlash in this process of introduction from corporations or fossil fuel companies lobbying certain countries during this upcoming process? Do you have any preemptive defense for such an altercation? I know this is not probably your expertise, but this will come down to a decision-making process, policy of individual countries. So maybe do you have something prepared, such as a supplement or a guideline document for this amendment? This is my question. Thank you so much.
Yeah, I mean, that's another brilliant question. I presume so. What we have been doing, I mean, as you said, it's not my area of expertise, and I'm not really leading the campaign. I mean, I'm trying to contribute to the campaign, but I'm not the master strategist. But one thing that I am engaged in with a few different organizations is conversation with business who are in support of the crime. So it may not be immediately obvious, but in the same way that there are businesses who support calls for, you know, the business and human rights framework, there are businesses who are supporting a new crime of ecocide. And in fact, I don't have it in front of me, I could have prepared it, but a very influential group of investors, which represent, you know, trillions, actually explicitly came out in favor of the crime of ecocide in October. And I think the reason is that they see it as that they will not be like businesses that are trying to be sustainable will then not be undercut by businesses who are not. So, you know, to a certain point, it gives them some economic advantage if there are hard legal, you know, flaws or limits on permissible activity. So there is some support. I can only imagine that there will also be, you know, some anxiety though. And I think the strategy is to try to work with businesses who are in favor, and then the grassroots campaign, you know, to make it, I mean, what is going to influence the politicians? It is for sure companies, but it's also, you know, their electorate and the population. And there is a pretty broad and active global campaign around the Stop Ecocide Coalition, which has branches, you know, all around the world. And when people ask me, like, what can I do, you know, to advance this, I always say, well, you know, make it an issue in your local sort of political landscape. Because I mean, the one thing we have on our side is the one thing that we don't have on our side, right? So the one thing we have on our side is the rapid deterioration of our climate. So at a certain point, those arguments are not going to be worth anything anymore. But hopefully we just need to get to that point, you know, as soon as possible. So yeah, I don't know. I'm also curious to see. I mean, if you have some suggestions, I would be very curious to hear them. When you were talking about the guide or the briefing document, what did you have in mind?
I was actually having my thoughts on, you know, the Framework Convention on Tobacco Control. This is a WHO treaty, and it's definitely having a backlash from the tobacco industry. Yeah. So there's a certain supplement to every article talking about how you should actually perceive such an introduction to your local law. So it basically tries to calm down the anxiety of the country trying to adopt this ratification, because once FCTC, this Framework Convention on Tobacco Control, this is the first and probably the only treaty of WHO. So This was also a brand new thing for them, and this had also, it's still having a backlash. It's having a backlash from Philip Morris. It's having a backlash JTI, BAT. So the fossil fuel companies are definitely similar. So once you have because you're probably introducing an article that is a paragraph that comes to the country's doorstep, and probably their ministers are looking at only a single paragraph. So when there is something similar to that, but when you provide them that this is not going to be that widespread, this is not going to be something that will interfere with your Ministry of, I don't know, investment or something else. So just to calm things down, to provide a perspective, maybe such as supplement, like a brochure or documents, maybe that might be useful.
That sounds really interesting. I will take a look. Yeah, is that easy to find online?
It's not. I think it is. There is an FCTC website, and there are supplements to certain articles, like 5.3, which is actually impeding tobacco companies to interfere or to even help, in quotation marks, the countries implement this treaty, because obviously the companies are lying and they're saying they're trying to help you implement this, and they try to be the nice guy, but they're actually not. So you try to distance yourself through a supplement to actually convince the government not to work with these guys, even if they do smile on your face.
Thank you. I will look that up.
All right. I can also share it with you. I can get in contact with my professors.
Wonderful.
Thank you so much.
Thank you so much for this excellent seminar, Professor Mackintosh. I will also like to thank you, our audience, for their insightful questions and insightful answers from you. And to our student working group who worked on preparing the questions, I thank you. I thank all of them. And now we come to the end of our seminar. And before closing, I would like to leave the floor to have your closing words, Professor Mackintosh.
Well, I would just say thank you again so much for inviting me. Thank you for the excellent questions. And I'm just so encouraged to hear about all of the interesting work that you're doing, and that you're exposing, but not just that you're researching yourselves as faculty, but that you're exposing all these brilliant young minds to these issues, because we really need all of you smart people to think about this. Now's the time for action, and as lawyers we can also do something. So it's very heartening for me to be with you all. Thank you for the invitation.
Thank you so much for your inspiring comments. We would like to be certainly in connection with you in our future works, and sure that we will connect with you again. And I hope everyone enjoyed today's lecture. And now I say goodbye to everyone. And thank you for this seminar. Thank you.
Have a great evening.
Thank you. Have a great day. Bye-bye.